A woman was apparently so irritated that a worker was hanging up holiday decorations that was blocking a bank drive-thru that she allegedly hit the worker with her car. That is what we're talking about, and we're going to break it down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey, so before we jump into this story, I have something I gotta tell you about. I host and executive produce a show called Crime with Jesse Weber, and now it is launched on Spotify. Yes, you can listen on the go. And this show puts a spotlight on those really shocking, infamous, controversial crime stories. We go from beginning to end, from the 911 call to the verdict. We go through body cams, police interrogations, interviews with the players in the case. We want you to have a full understanding of the story from all sides, so you can follow Crime on Spotify right now. Just click the link below and in the description. It's supposed to be the most wonderful time of the year, right? But you have one apparent Grinch in Missouri who is accused of committing a crime that ended with a man recovering from injuries this Christmas season. So it was around 9:30 a.m. at the Sullivan Bank in St. Clair, Missouri. This was back on December 2nd. And according to police, an employee was outside hanging Christmas lights around the drive-thru section of the bank. And he was using a lift to reach some of the higher parts. So the whole drive-thru part of the parking lot was blocked off for safety. Now, I think you can imagine what happens next with this being blocked off, because that is when authorities say 41-year-old Jemma Allen arrived and wanted to use the drive-thru, but obviously she couldn't. So according to a probable cause statement that was filed with the court, what happens next was apparently all caught on bank surveillance footage. So talk about a key piece of evidence. When this employee tries to tell Allen that the drive-thru, was closed for a little bit because of hanging up the decorations, she allegedly starts arguing with him. He starts to back away, but when he goes to pick up a storage tote, Allen allegedly smashes the accelerator of her car, hitting him with her Kia Soul and sending him up on the hood of the car. The employee reportedly held onto that hood as the car just sped across the parking lot. It's almost like something out of a movie if this wasn't real life. And then he was eventually flung off onto the ground. Now, she didn't stop, according to police. She takes off from the scene. First responders arrive at the bank. They rush this employee to the hospital with, quote, visible injuries, though more details weren't provided, although the reporting indicates these were not life-threatening injuries, and he obviously survived this. But police, they end up tracking out. They find her at her home. They find her. They find the Kia Soul. And Allen reportedly told the officers that the victim was, quote, an a-hole. According to the probable cause statement, Allen told officers that the victim yelled and cursed at her when she approached the drive-thru, which caused her to, quote, become frantic. And she says in that panic, she put the car in drive instead of reverse, that this was an accident. Now, that is very different from what witnesses at the bank say happened, because they allege that when she was told to turn around, Allen screamed, "F you, mother effer," and then hit the accelerator. Now, the police chief says that she even tried to pull away from officers during her arrest, which got another charge for her. She was taken into custody, booked into the Franklin County Adult Detention Center. Allen is charged with assault in the second degree and also resisting or interfering with an arrest for a felony. Now, under Missouri criminal law, a person commits assault in the second degree if that person, 1, attempts to kill or knowingly causes or attempts to cause serious physical injury to another person under the influence of sudden passion arising out of adequate cause, or 2, attempts to cause or knowingly causes physical injury to another person by means of a deadly weapon or dangerous instrument. A car would certainly qualify for that. Or 3, recklessly causes serious physical injury to another person. Now, it's not entirely clear which of those categories she is being charged with specifically, but what I can tell you is that based on our research, this is a Class D felony that carries up to 7 years in prison and a $10,000 fine. And by the way, you also have that other charge where an additional 4 years could potentially be tacked on if she's found guilty of the resisting arrest charge. Now, Allen was reportedly given a $100,000 bond, which she posted the next day with the help of a bail bonds company. And as part of her bond, she can't have any contact with the victim or any of the employees at Sullivan Bank. We checked into Allen's background, by the way, and it turns out he's also facing another assault charge in St. Clair Municipal Court from back in May, but details about that alleged assault weren't available. But let's talk more about this. Let me bring on former prosecutor Safa Robinson-Ferrer. What a story to talk about. Initial thoughts, initial impressions about, does these kind of things happen? Did these things happen a lot when you were practicing?
Unfortunately, these things do happen, and they happen a lot more than we would like to think. And especially there's something about the holiday
Yeah.
season where things start to get a little wonky, for lack of a better way to put it. We start to see a significant uptick in mental health diagnosis and acts that are related to, mental health emergencies and things of that nature. So it's not very uncommon to see things like this happen at this point in time, unfortunately. So not a surprise here, especially during the holiday season.
Which of those categories do you think of second degree assault this fits into? And I'll read it again. Attempts to kill or knowingly causes or attempts to cause serious physical injury to another under the influence of sudden passion arising out of adequate cause. Attempts to cause or knowingly causes physical injury to another person by means of a deadly weapon or dangerous instrument, or recklessly causes serious physical injury to another person. Which do you think that applies here?
I think it's going to fall between the first two or three categories. There's certainly an argument to be made with respect to attempted murder. You're hitting somebody with your car. What do you possibly think could happen? And there was an intentional means of doing that. So that's one thing. That may be a stretch here. And this may more so fall into the second and third category, which is causing serious physical injury in the heat of a passionate moment, or also causing serious physical injury by way of a dangerous instrument, which is absolutely here. I think that whatever transpired between the defendant and this bank employee caused some type of uprise or uptick within her emotions, and she ultimately decided to allegedly put her car in drive and hit this individual with her vehicle. And yes, a car is considered a dangerous instrument. Anything can actually be considered a dangerous instrument if you use it in a way that is to bring about serious physical injury to another individual.
Is the only defense that you see right here where she claims I accidentally put the vehicle in drive, I thought I was going in reverse, this was an accident. Let me amplify this and let me think about how this would go. I accidentally put the car in drive and I made a mistake. I hit him. I'm in such a panic. I don't know what to do. Yes, I did hit him, but it was an accident. He's on the windshield. I stop. He falls. In a panic, I leave the scene. But it doesn't mean that I committed a crime here necessarily. I'm stretching because I guess, look, the idea is if you flee the scene, that looks really bad. And that also goes against what witnesses said where they saw her go accelerate the car. But I guess that's the only defense that she can go, right?
Me that would be the only defense, is that she mistakenly put the car into drive and was meant to put it in reverse to back out. But the thing about it is that all of these witness statements negate what she's actually saying. And I expect that the video footage from the bank is going to negate that as well. The thing about this is, and with cases like this, is that one of the things the prosecution is going to be able to do is that they are going to be able to present evidence that shows a lack of mistake on her part. So while she may say, hey, my defense is that I didn't mean to do this. This wasn't intentional. I meant to put my car in reverse. What the prosecution is going to do is they're going to take all these key pieces of evidence, these witness statements, the video footage, the conversation that took place before this incident occurred, and say to the jury, this was no mistake. She knew what she was doing, and I'm going to ask that you find that she knew what she was doing and that she intentionally committed this act beyond a reasonable doubt. So the prosecution will be able to show a lack of mistake on the defendant's part with respect to this.
What about the idea if there really was a fight, not physical fight, but a verbal fight, and let's just assume for purposes of this that this bank employee was verbally combative with her and cursed her out. I don't think that would necessarily change the outcome of her being found guilty, but would it change? We talked about sudden provocation. It's not an excuse to the crime. It's actually an element of this crime. But would it lessen the degree of her punishment at all, or no?
I don't think it's going to. Legally, there's no mechanism to lessen the degree of punishment with respect to this. And one of the things that the jury is going to have to do if this ever went to trial is bring their reasonableness into that jury room, to bring their common sense and things of that nature. Does somebody saying something that could be offensive to you or egregious to you in nature or offensive to you in nature, does that mean that you can put your car in drive and run them over and possibly kill them? Absolutely not. I don't think that any reasonable person is going to look at that as something that was in any way justified based off of whatever that conversation was that was had between the two.
If this goes to trial, she has to take the stand, right? I mean, she doesn't have to, but I feel like this is a case where she would have to explain her behavior.
If this case were to go to trial, this may certainly be a case where we would want to explore whatever psychiatric defenses are available to her, if there are any that are available, and that's something that her defense team is going to want to explore. She may possibly have to take the stand, but if there's a psychiatric defense and we are able to put on, or the defense is able to put on a psychiatric witness to essentially say that this is what she was going through at that moment, this was her diagnosis, and this was the response, that would probably be better than her being placed on the stand. This is clearly a woman who may not do well with confrontation, verbal confrontation in a court or in trial. And as most of us know, when somebody's on the stand testifying as a witness and subject to cross-examination, that can get pretty testy between the witness and the attorney that's cross-examining her. So I don't think that she needs to testify. I think that if they present this in an element of a psychiatric defense, that component will be able to satisfy her possible need to testify.
And the resisting arrest charge, while it's a separate charge, it's almost similar characteristics to what the other charge that she's facing, right? You mentioned it before, this resistance, this fighting back, this confrontation. Talk to me about how that other charge could actually play into the overall case.
Well, with respect to the other charge, and I don't know if it's attached to the indictment or if it's being handled separately, but that second charge, the prosecution is able to piggyback that onto the assault charge to basically continue to show the jury that this individual has a propensity to not follow the rules, to become combative and all of those sorts of things, and basically say, this is not someone who should have any sympathy, for what she allegedly did or caused to this particular individual. And she also didn't respect law enforcement enough to comply with their orders after she was placed under arrest for allegedly causing this injury to this individual. I don't think that a jury is going to be quite sympathetic to the defendant in this case when there's an allegation that she ran over an individual who was simply trying to do their job, and not only do their job, but do their job during the holiday season. Things can be very difficult for individuals, financially, and people have families that they want to spend time with during this season. So for there to be an allegation of her to essentially possibly attempt to take the life of this individual, but not only that, to impair their physical body with a serious physical injury, I don't think that there's going to be much sympathy from a jury with respect to that. In fact, I think the best way going forward in this case is probably to see if there is any mental health diagnosis and engage her in treatment prior to the possibility of trial.
I think you might be right. Given this fact pattern, could be tough to defend, but we'll see. Safa Robinson-Ferrer, thanks so much for coming on. Be safe this holiday season. Who knows what's going on out there, but really appreciate it.
A lot. Thank you so much, Jesse.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.